How is the U.S. Supreme Court's follow-up to the McGirt ruling going to impact you or your loved one? My name's Ted Hasse. I'm an attorney practicing in federal and tribal courts in Oklahoma. United States versus Castro-Huerta is a decision just came down in the last few weeks from the United States Supreme Court. It is a follow-up to McGirt. The McGirt decision is just beyond the scope of this video. I've done other videos, and if you need to find out more about McGirt, you'll probably want to check out some of the other videos that you find on this channel or website. What I'm going to talk about today, though, is U.S. v. Castro-Huerta. This is a decision that is a follow-up to McGirt that impacts jurisdiction over non-Native Americans who allegedly commit crimes against Native Americans in eastern Oklahoma in Indian country. After the McGirt ruling, jurisdiction was stripped from the state of Oklahoma for all crimes that were committed against Native Americans or committed by Native Americans. Any member of any nation could no longer be prosecuted by the state of Oklahoma. They had to be prosecuted by either the federal government in federal court on federal criminal charges or by one of the nations, whichever nation they committed the alleged offense in. Now, since this new decision, here's the major change. Nothing has changed for defendants who are Native American. What has changed is that non-Native American defendants who have a victim, an alleged victim that is Native American, can now be prosecuted by the state of Oklahoma again. However, here's the tricky part. That doesn't mean that jurisdiction has been stripped from the tribal court or from the federal government. The federal government can continue to prosecute when they want to prosecute. That's called concurrent jurisdiction. That means that the federal government can now prosecute non-Native Americans committing crimes against Native Americans, and the state of Oklahoma can now, again, prosecute crimes committed by non-Native Americans against Native Americans. And then with tribal court, there's a small category of crimes which tribal courts can handle defendants who are non-Native American, and that's under the VAWA, basically a federal statute that covers, and expands coverage related to domestic violence issues. Some years ago, Congress passed a law granting jurisdiction to nations, tribes, in cases of domestic violence, whereby they can prosecute a non-Native American in tribal court if the victim is Native American. So we're getting a lot of calls from clients, particularly clients who are pre-indictment, who have not yet been indicted but are under federal investigation. A lot of them were sort of hoping that their case was among the thousands that were purportedly being handed back over from the U.S. Attorney's offices, that's the federal prosecutors, to state prosecutors. I have at least one client who discovered that once in his case, the feds had already picked up his case and already started their investigation, and although they could have handed it back to Tulsa County, they decided not to. He woke up to an FBI raid, and he's now going through the process of federal prosecution. So people need to be aware that in practice, while this is going to mean going forward fewer federal prosecutions, if there was already a federal prosecution or federal investigation in place, it may be likely that the federal prosecutors at the U.S. Attorney's Office may go forward with their charges and seek an indictment. If you have questions about how this new sort of landscape of jurisdiction could impact you or a loved one, please give us a call at 918-932-2800 and ask for me, Ted Hasse.